5 seconds to go. Start. In crafting the relief, the court was mindful of the long exercise of rights by those acting as she-baits. The initial scheme framed by the High Court comprised 18 members on the managerial board, of which 12 were she-baits. The court modified this to a board of 11 members with 5 she-baits and a majority of Hindus who were not she-baits. The protection of the trust property is of paramount importance. It is for this reason that the right to institute proceedings is conceded to persons acting as managers, though lacking a legal title of a manager. A person claiming to be a de facto she-bait can never set up a claim adverse to that of the idol and claim a proprietary interest in the debuter property. Where a person claims to be the de facto she-bait, the right is premised on the absence of a person with a better title, that is, a de jure manager. It must be shown that the de facto manager is in exclusive possession of the trust property and exercises complete control over the right of management of the properties without any hindrance from any quarters. The person is, for all practical purposes, recognized as the person in charge of the trust properties. Recognition in public records as the manager would furnish evidence of being recognized as a manager. Significantly, a single or stray act of management does not vest a person with the rights of a de facto she-bait. The person must demonstrate long, uninterrupted, and exclusive possession and management of the property. What period constitutes a sufficient amount is determined on a case to case basis. The performance of religious worship as a posari is not the same as the exercise of the rights of management. A manager may appoint one or several pujaris to conduct the necessary ceremonies. In the ultimate analysis, the right of a person other than a de jure trustee to maintain a suit for possession of trust properties cannot be decided in the abstract and depends upon the facts of each case. The acts which form the basis of the rights claimed as a she-bait must be the same as exercised by a de jure she-bait. A de facto she-bait is vested with the right to institute suits on behalf of the deity and bind its estate, provided this right is exercised in a bona fide manner. For this reason, the court must carefully assess whether the acts of management are exclusive, uninterrupted, and continuous over a sufficient period of time. A final question that is relevant for our present inquiry is whether a de facto she-bait can claim a right to continue indefinitely in office. As seen earlier, a de jure she-bait and a de facto she-bait exercise similar rights in the limited sense of acting for the benefit of the idol. Even absent an averment of mismanagement by the she-bait, a person may institute proceedings under Section 92 of the Code of Civil Procedure 1908 against a de facto she-bait for the settling of a scheme. In this view, legal certainty and the sustained interest of the deity would be served by circumscribing the claim of a de facto she-bait to continue as a matter of right in perpetuity. In Gopal Krishan Ji Ketkar versus Muhammad Jafar Muhammad Hussain, the plaintiffs instituted a suit praying for a declaration that the second plaintiff is the guardian and wahiwatdar of the dargah. The defendant claimed to be its rightful manager and mutawali. The plaintiff's family were managers since 1870. Since 1902-03, the defendant was given the right to manage prayers during a certain period every year in the temple and collect the offerings for his upkeep. Stop.